back to Environmental Laws with Thompson Hine. I'm happy to be back with you for another episode. I'm Joel Eagle, a partner in Thompson Hine's Environmental Practice Group in our Cleveland, Ohio office. In this episode, I was joined by my environmental partner, Heather Richardson, from our New York office, along with Tom Simmons, Dan Titus, and Mark Wright, 3 PFAS experts at environmental consulting company HRP Associates. With PFAS continuing to make legal and technical headlines on a daily basis, we started our discussion with EPA's recent announcement regarding PFAS diligence requirements to qualify for federal Brownfield grant funding, and then focused on other PFAS risks and liability management opportunities. With that, let's get to the episode.
Everybody, welcome to P3, the PFAS Pulse podcast. This is HRP's companion podcast, the PFAS Pulse newsletter, an aggregator of all things PFAS. And on this special episode, we are joined by our friends from Thompson Hine to talk about the intersection of PFAS, brownfields, and legal liability. Folks, would you mind introducing yourselves, starting with Heather?
Hi, everyone. Thanks for inviting us on the show. My name is Heather Richardson. I'm a partner at Thompson Hine's New York office. I'm in the real estate and the environmental practice group. I've been at Thompson Hine for 32 years, and I love all things environmental, transactional, including PFAS issues and brownfield redevelopment.
Good afternoon, everyone. This is Joel Eagle. I'm a partner in Thompson Hine's Cleveland office in the environmental practice group. My practice focuses on all things cleanups of hazardous waste sites, CERCLA, RCRA, brownfields. I'm the lawyer that does enforcement defense and compliance counseling. And for the last 10 years or so, I've had a particular interest in counseling clients on PFAS issues.
Excellent. And over here on the HRP side, we've got myself, Tom Simmons, host of the PFAS Pulse podcast, also joined by CEO Dan Titus and Senior Project Manager and DEC Contract Manager Mark Wright. Mark, do you want to tell us a little bit more about yourself here? I think this is your first time on the podcast.
Sure, yeah. Thanks for having me, Tom. I've been at HRP for about 15 years doing various project managements, and over the last, I would say probably 7 years, been getting pretty deep into PFAS investigations and kind of planning for PFAS remediation as soon as we get some viable technologies, but working on kind of forensics and figuring out where they're coming from and what the different species are and what it all means, and also kind of what it means in regards to our brownfields clients.
Tom's looking at me, looking for me to say something.
Yep.
I'm Dan Titus. I'm CEO here at HRP. As it relates to this particular topic, I'm sort of responsible for the strategic development arc of our PFAS investigation and remediation section, including CapEx spending on technology and trying to suss out market spaces, working on development of brand recognition in the marketplace through things like this podcast and so on and so forth. So PFAS, yay.
Yeah, we're getting pretty good at that. Those introductions. It's like we've had some practice. So first question for our friends from Thompson Hine. We decided to get together for this episode after I read your newsletter on the December 2025 EPA FAQ regarding PFAS diligence and liability defense for brownfield grant funding. I was wondering if you guys could tell us more about what that was and what prompted you to respond to it.
Sure, Tom. This is Joel. I'll start by explaining a little bit more about the background of PFAS at the federal level, and then Heather will talk specifically about the Brownfield FAQ. So as a background, most of you know, but maybe not, PFAS at the federal level is regulated under a variety of environmental laws. What we're talking about today are the regulation of 2 PFAS compounds out of the 15,000 or so that exist. EPA has finalized a rule in 2024 that listed PFOS and PFOA as CERCLA hazardous substances. And what that means is that EPA can now regulate, can go after parties for investigation and cleanup of sites that might have PFOS and PFOA. Where we get involved is in a lot of times in the diligence world, we want to know and work with our consultants like HRP in understanding what a site has, whether it might have PFOS or PFOA? And if so, what are the risks before a client buys a property, buys a company that owns property? The EPA final rule was finalized in 2024, immediately challenged in court, and the litigation is ongoing right now. At the beginning of the Trump administration, the EPA was directed to revisit a lot of regulations that had been passed in the prior administration and decide whether it wanted to keep them or get rid of them. And the PFAS CERCLA hazardous substance rule was one of those rules. So it took about 8 months for EPA to decide what it wanted to do. And in September of 2024, it decided to continue to defend the rule in litigation. And so as of this moment, PFOS, and PFOA remain CERCLA hazardous substances. And in January of 2026, the oral argument for the ongoing litigation was held, and we're waiting with bated breath to see if the DC Circuit Court of Appeals agrees with the EPA to keep these two substances as CERCLA hazardous substances or not. So that's going to lead us to why do we care about these two compounds with respect to brownfield grants, and Heather is going to talk about that.
Thanks, Joel. That's exactly right. The December FAQ that we're talking about now makes clear that if you want to obtain this brownfield funding, you have to go through the innocent purchaser defenses, basically through a phase 1, to show that you're not a responsible party and you're innocent. And that's important for this particular funding that we focused on in our article. But I will also say that across the country in various states, I'm finding that now, as part of eligibility for these grants, you do have to consider PFAS as part of the application. So it's really important to get your arms around PFAS if you're looking for brownfield funding, either at the US EPA level that we wrote about or in many of the other state options.
Excellent. So could you just make a brief statement on that intersection of PFAS and brownfields from the perspective of an attorney? I think whether you're the holder of a brownfield site or a prospective developer or someone hearing about brownfields for the first time and looking to learn more, I'm sure any legal insight you can provide on how the growing issue of PFAS interacts with brownfields would be invaluable to our listeners.
I'll start with that, and then Joel, you can get a little bit more specific on the listing. PFAS is going to be part of any transaction, not just brownfields. And brownfields are properties that have been used for industrial purposes in the past, and that's most of the listeners on the show are interested in that. But any transaction I'm working on, whether it's a purchase and sale of a business, whether it's a lease or a property, whether you need to get financing, the focus is on PFAS. It is the most critical part of my transactions right now. And so we have to assess, do you want to test or not test? We're going to talk about that in a minute. But practically, from a transactional perspective, you cannot ignore PFAS because of the unknown liability and the risk allocation as to who would be responsible. So I'm seeing it in everything I work on. And as far as a brownfield site specifically, there's a liability issue, but then you're also concerned about whether there would be development costs relating to PFAS. So as an example, if you're redeveloping a site and you have to dispose of soil off site, a lot of landfills are saying, we want to know if there's PFAS in this soil. Did you test? So you want to know that so you can budget into your brownfield redevelopment and your development of the site, those types of costs. Same with groundwater disposal, and you can talk more with Mark about how he handles that. But Joel, could you just give an update on the listing and how you see it in your practice?
Yeah, 10 years ago when I started talking about PFAS, it was a new topic to me, and it was a new topic to most of the world. And when I first started speaking and doing podcasts and other presentations, most people didn't even know what PFAS were. Today, not a day goes by where I don't say the word PFAS in my practice, and it's become a part of everyone's day-to-day thinking. I mean, in fact, I don't know if you all saw the news a couple of days ago, but 3 Olympic athletes were disqualified from the Olympics for using PFAS ski wax on their skis. So, we've really jumped the shark or gotten to a point where, it's everywhere. It's in our, Gore-Tex clothing. It's in our nonstick cookware. It's everywhere, which is it's an interesting concept just for the community. But where lawyers get involved is our clients are now getting information requests from EPA and state agencies. They're getting investigation demands at Superfund sites and state sites, whether there is a history of PFAS usage at a property or not. It's kind of like a checklist item now for most federal and state requests at sites that why don't you just go and take a couple of soil samples or groundwater samples and see what you have. And it becomes a real liability for our clients to make the decision of whether they go along with that request or not. Because if they do, given the ubiquity of PFAS in the environment, there's a fairly good chance that you're going to find it. And then you have really opened up Pandora's box. So we want to be really careful when we advise our clients, and consultants like HRP are very careful as well in how you respond to these information or agency demands.
From a purely technical perspective, I think it's worth pointing out in the context of PFAS, because I think sometimes this gets lost in sort of the general real estate transaction liability conversation. The big risk with PFAS, even just outside of the site and the site boundaries itself, is its ability to migrate off property. Off-site liability with respect to PFAS is much, much greater, in my technical opinion, than it is for virtually any other compound. It sort of reminds me of back in the day when MTBE used to be a thing that was added to gasoline in densely populated metro areas. MTBE was very mobile. And so, virtually every gas station on the corner had a big MTBE plume that would migrate off site. So you'd have all these sort of extra off property impacts. PFAS is much the same. The difference is that PFAS, it's already sort of been said here, but PFAS is much more ubiquitous in the environment, and the number of sources of PFAS, we're really just sort of starting to scratch the surface. It can go from, the wax on the bottom of skis to spray-on coatings to everybody's favorite fire suppression foam. But all of it is highly mobile. And sometimes when you get off site and you're looking at a PFAS impact, it's very hard to discern and then describe which part of the PFAS profile belongs to which site. So I think that that's a big issue in the future that people are just starting to grapple with, but I think that's going to be a big problem.
Yeah.
I agree. And I would say from the transactional perspective, one of the things, especially if I'm representing a buyer, you want to be sure you're not purchasing a site that is a source where you would have all these off-site issues, because we're finding, and I know we're going to get into requests from governmental agencies to test off-site, particularly like New England or New York where Mark is, there's a lot of drinking water wells. And so if you end up purchasing this property, and I'm seeing this now, getting requests that, now you have to test off site and you're responsible. And by the way, everyone knows about PFAS and there's going to be third-party lawsuits. It's definitely something to think about as part of the diligence in a transaction for sites that could be a source of PFAS.
And I'll just conclude that thought with the idea that going back to the Brownfield grant FAQ, I'm going to quote an important part of it. EPA says, now that PFOA and PFOS are designated as CERCLA hazardous substances, Brownfield's grant recipients who wish to use funding to assess and clean up sites with PFOA and PFOS must demonstrate that they cannot be held potentially liable under CERCLA 107 for the contamination at the Brownfield site. Now, this is going to be really difficult given the ubiquity of PFAS in the environment to show that you are not a current PRP at a site, because it just might be there, whether to the point about migration, very fast migration in groundwater, it might be in the groundwater at a site. In order to show that you're not the responsible party, the burden really shifts to you and makes the Brownfield grant funding much more difficult to obtain.
So one of the questions that we've had come up with a lot of our clients is how do you respond and when do you accept requests from EPA and state agencies to test for PFAS, kind of both on and off site? I guess, what are the potential risks someone has to consider, and how should people respond to that request?
Well, I would say before 2024, before the final CERCLA PFOS, PFOA rule was finalized, it was somewhat easier to respond to EPA because as an attorney, we could legitimately say that these are not regulated under CERCLA as hazardous substances, and therefore we don't believe that we have liability in the responsibility to do the testing that was required. Since EPA finalized the rule, that argument has become a lot more difficult. And where we are right now is evaluating these requests on a case-by-case basis. And I'm sure that HRP comes up with a similar thought process here. You don't want to accept every demand that an agency gives you, but you have to also have a legitimate basis to decline or push off that request. So as an example, if your site is a PFAS manufacturing location, that argument is going to be difficult. If you're at a municipal or a DoD Air Force base where HRP fire suppressant was used in the past, denying the request for sampling is going to be difficult. However, looking at a site where your client manufactures something where it traditionally had nothing to do with PFAS, you might have a much stronger argument. So, we really look at these requests on a very much case-by-case basis and work closely with consultants to make sure that we have a technical and a legal basis if we're going to push back on that. Heather?
And Mark, I guess I might turn this to you because I have a few sites in the New York Brownfield program, and we're not having good luck. I mean, the state is trying to request both on and off-site testing, and essentially will say, we're not going to give you your closure unless you do it. So it's tricky. It's based in other states like New Jersey. I'm finding the same thing, that you really do not have a lot of flexibility in saying you will not test. And we raise all the issues. Like you said, there's 10 other potential sources. Why would we test? We're a deep pocket. We're a big corporation. We know that if you find it, you're going to blame us. Have you seen similar things in New York State, Mark?
Definitely. We've kind of early on, several years ago, gotten requests on starting with kind of Superfund sites that are in monitoring to do off-site testing. And we've had mixed success in pushing back from a scientific basis of the argument, kind of describing the different aquifers that exist and where the drinking water resources are versus the aquifers that the PFAS are in. And we have seen DEC be open to those arguments. Have been mixed success with them. The on-site testing for any site in the Part 375, it's the New York cleanup standards for the other people in the audience, I guess. That is pretty much unpushbackable, I guess. It's part of the regulation that you're going to test for PFOA, PFOS, the whole 1633 list. But again, you can come back with the argument from a scientific perspective and a receptor perspective about going off-site to mixed success, depending on the situations of the site. But we have had success with making those hydrogeologic-based arguments.
I'd just like to stick in real quick from an operational perspective too. I think, sort of the classic sort of brownfield setup, it's a municipal brownfield. So the front end of the brownfields process is being managed by a municipal client. And, what we have seen across the, hundreds and hundreds of brownfields that we've done, is that, typically what the municipality is looking for is kind of like a first blush sort of look at a site to sort of do like a basic characterization of the environmental history and then, the release potential, and then sort of like a binary question, is there or is there not a release, yes or no, on the site? And then generally they're looking to sort of pass it off at that point to a prospect developer. And the lawyers can tell everybody all about the liability problems and transfer there. But importantly, that sort of OG characterization that's happening on the municipal side is not really built for highly specific characterization of contaminant profiles. It's really built around simple testing ideas. And the issue with PFAS, of course, is that since it's so ubiquitous and the contaminant profile is so large, in order to really sort of assess whether or not there is like real liability associated with a release on a piece of property, it requires a more detailed investigation that typically the municipal client is not prepared to support. So that will change, I think, but understanding that the expectation that currently exists in that part of the program on the municipal client side versus the reality of trying to fully characterize a release of PFAS against all the other sources that might be out there, there's a little bit of a mismatch there right now, in my humble opinion.
I think that's a good point, and really the question of when to start looking for PFAS is pretty important as you scope out your investigations beyond transaction screening. If a client already owns the site and you're starting to look at potential programs to go into for cleanup and where other sources of funding can be available, making that educated decision as to when to do it in the context of those programs is very important, because you are going to find it whenever you test for it.
We'll tell you. So
yeah.
war stories. We're working on a site in central Connecticut right now. It's not a brownfield site per se, but it has all the hallmarks of a brownfield site. It's just that it's privately owned. And working through some issues with the Connecticut DEP, we have found aerial deposition on this piece of property. We have 20 parts per trillion PFOS basically across the entire site without a particular source because of the history of the site. And even just that sort of simple problem in the context of brownfields becomes really, really difficult because aerial deposition is a thing, but it's not something that people are really talking about from a regulatory perspective yet. That's also coming, but it just sort of emphasizes how difficult the characterization of this material can be on a piece of property.
Is this in the Transfer Act?
It is, yeah.
2 weeks later.
Yeah, right.
Well, it's been in the Transfer Act since like 2001, so not going anywhere.
But how does that? Do we know how that's going to change with the RBCRs?
This site is a special site, and there's state involvement and funding and whatnot. So I don't want to say that it's extra regulatory, but I would say that the Connecticut DEP has given it some sunshine that other properties are not going to get.
Gotcha.
So let's just leave it at that.
Okay. All right. Moving on to our next follow-up. I think we would like to talk about how to perform a PFAS fact investigation for a facility or a company to determine PFAS risk for contamination, for getting sued. Heather, Joel, what do you guys think about that?
Yeah, I've come across this several times at this point. We get a lawsuit for our client who has, at first blush, no knowledge of any PFAS usage historically at the manufacturing facility at issue. Products that manufacturers don't use PFAS, shouldn't use. If they use PFAS, it would be bad for the product. So they know that they've never intentionally used PFAS before, and yet they're in a lawsuit and have to defend it. So the first step, Tom, is really what I like to call find the PFAS profile, the PFAS story for that facility. That involves interviews, it involves pulling documents, historical documents, really any information that you can gather that will help shift the burden to show that you did not use PFAS. And if you did, it was in such a de minimis or de micromis amount that you can't possibly be responsible for a source of water, drinking water impacts well down the way. So, at a high level, what we do is we begin the process by, and we do this all under privilege, by the way, having an attorney involved and marking things as privileged and doing the interviews under privileged is extremely important. But it's really a matter of starting the interview process with those in knowledge, those in the manufacturing facility, EHS managers, chemists, supply chain, purchasers, anyone who's involved in the purchase of raw materials or the use of the raw materials. And you interview them and you try to understand over the past many years, depending on what the time frame is, what has been purchased. You look at SDSs. Unfortunately, SDSs, as a lot of people know, don't do a very good job of saying whether there's PFAS in the material. So an SDS might be useful, but it's certainly not going to be the end all in your evaluation. So you look at all the documents you can, you gather everything, you perform your interviews, and at the end of the day, we've done this several times, and you hope it turns out well for your client, that after this investigation, there really is no legitimate basis to say that a manufacturing facility discharged PFAS, certainly intentionally. Now, the one point that I'll make is understanding the water that's coming into your facility is very important, because even through all of these other investigatory efforts, you might find you didn't intentionally use PFAS, but if you're discharging PFAS, it actually might be coming from influent water, because we use the word ubiquitous over and over again. PFAS is in water. It's in processed water that comes into the facility. So do not discount the possibility that your discharged water with PFAS is actually just a flow through from PFAS that came into your facility.
And I would say from a transactional perspective, I push back hard on all the consultants that I work with, because I get it. Consultants are nervous and they don't want to miss PFAS. And like we said, it's ubiquitous, but I push hard that it be treated as any other contaminant in a phase one, so that we want the deal to go through and we're not trying to create false issues. So I push back on any speculative language and require the consultant to, if there's a database listing that a site is on the PFAS database list, that doesn't automatically mean it was even used or that there was a release. So I just caution the listeners to be special attention to the PFAS sections of phase ones, because more often than not, there's some conservative findings that I think you could push back on. You do have to look and see if there were any fires at the facility to see if there could be firefighting foam. But we go through, the whole checklist of PFAS issues, and you're not trying to bury issues, but you also don't want to create a problem. We wouldn't be able to close any transaction if we worry about, if it's any possible source of PFAS. So that's how I handle it in my day-to-day.
How are insurance or liability transfer entities used to mitigate risks?
I'll take that. So insurance, interestingly, a lot of people think that PFAS is automatically excluded from policies, from a pollution legal liability policy, and that's not the case. And you can do basically a desktop, like I just explained, to get the underwriter comfortable that there's no likely sources of PFAS to get it included in a policy. I've had a lot of recent success on that. I think for a while the underwriters were really nervous about it, but now it's a really valuable tool to allow the deal to go forward and give some protection if there's something that you don't know about. So I urge the listeners to work with a reputable environmental broker, not just a general, but an environmental broker that understands this stuff, and you might be able to get some protection that way.
Historically speaking, I would say just, mine your historical insurance policies, do your insurance archaeology to see if you might have an old policy that doesn't have a pollution exclusion or an exclusion that might not eliminate the possibility of getting coverage. Some states, most states are pretty strict on the pollution exclusion, but there are some states where you might have a better chance. So do not forget about your old historic insurance policies.
On sort of this topic, but also going back to the previous topic a little bit, your last two answers, how they're kind of leaned into something that I had heard a regulator say the other day, and I want to get your thoughts on it, I guess, is they said PFAS is no longer an emerging contaminant, it's just a contaminant. And I guess, what's your opinion on it?
Yeah, I agree. And actually in my definitions and transactions, I list PFAS, just like you list asbestos and lead, there's the laundry list. And I list PFAS separately and then add emerging contaminants because I'm sure there's something new that we haven't thought of, and we can talk about that in 5 years when that's our next issue. But yeah, it's not emerging. Okay. Joel, do you agree? We've talked a lot about the definitions. I think it's not an emerging contaminant anymore.
Yeah, I definitely agree. I mean, by definition, an emerging contaminant is a contaminant that is not yet regulated. And we've got at least PFOS and PFOA at the federal level, and we've got several other PFAS that are regulated in drinking water and soil in many states. So yeah, just broadly speaking, to call them emerging contaminants, you have to be careful about it. Although because there are so many PFAS, yeah, you could say that many other PFAS would still be considered emerging.
Yeah, and I think from the investigation standpoint, it seems like it's well understood and not really as much of an emerging contaminant, but from the remediation side of things, it's still very emerging, I feel like, as there's not a lot of good mature technology out there to deal with it.
I think it's, anecdotally worth pointing out in the context of this conversation also, even outside of the status of, the litigation around, its Superfund designation and where that all ends up. The horse is kind of out of the barn at this point. So, for those of us who, are up to our elbows in all various and sundry manufacturing chemicals, such as it is, it's always been that PCBs, asbestos, and chlorinated solvents are kind of like, the trifecta of the publicly known methyl ethyl bad stuff, if you will. And I think really what's happened from sort of like a sociological perspective, that PFAS has now entered into that conversation. The public is very aware of PFAS and that PFAS is bad. And so, I think regardless of where all the rest of that ends up, it's gonna get regulated at the state level. It's gonna become a banking issue. When banks want to underwrite a piece of property that has a PFAS problem outside of the particular cleanup standards, so on and so forth. The horse is out of the barn. PFAS is just part of it now. I
agree. This is my 32nd year as practicing law, and I've never had friends interested in my practice at all, but they know about PFAS. And I live in a small town in Connecticut where we're all on well water, and they want to talk about it. And I've never had anything like it in my career.
Yeah, you're not going to be able to convince people that it's not bad for you at this point.
Dan, the horse is out of the barn. And for anyone who says, well, the current administration is deregulating, so, maybe this is just going to go away. It's not going away. It's not going away because we see what federal EPA is doing right now. They might be scaling back a little bit, for example, removing a couple of the drinking water maximum contaminant levels and revising the reporting obligation under TSCA to be a little bit more lenient. But at the same time, the EPA is regulating PFAS. They're defending the CERCLA rule. They continue to seek enforcement actions for dischargers, and they continue to really push Superfund site investigations and cleanup. So I think at this point, it doesn't matter what administration we're talking about. PFAS are here to stay.
Yeah, and this is a little outside of the context of the Brownfields conversation, so I apologize for taking us on a tiptoe through the tulips here. But I think another sort of important thing to think about with respect to PFAS regulation is the process that we're sort of going through right now. And I'm not sure that everybody really understood this when we first started, sort of establishing standards. Like if our standard is going to be like 2 parts per trillion, for everything, just making up numbers here, right? Then the word ubiquitous is almost sort of underserves the distribution of PFAS in the environment. 2 parts per trillion is on every street corner everywhere in America at this point. And so, you kind of get to a point where you throw your hands up and you say, well, it's everywhere. So what do we do about it? And so it's nowhere. I think that, if EPA were to, this is just my personal opinion, if EPA were to sort of pull back threshold contaminant standards a little bit, it would allow us to focus more on actual releases. So bring back before the comment I made about aerial deposition. I don't know how you unpack that. I'm not even sure that you could even figure out what the potential source of that contamination is, say, in an urban environment. So there's a lot of bringing your hands and kind of throwing them up as to what to do about it. But, there are actual sites that have legitimate and significant releases that you can point to and say, oh, that's a source of contamination, point source of contamination in the environment. And that's something that we can directly address. So I don't know. My hope is that some of the evolving sort of case history here will sort of take us in that direction where we can sort of address actual releases as opposed to the ubiquitous presence of the stuff in the environment.
How is the owner of a brownfield site impacted from a liability standpoint by the presence or the potential presence of PFAS? Would this be a liability for them, and would it have an impact on their funding?
Yes, and I think we covered that a little bit in the beginning, that a lot of these brownfield funds will have eligibility requirements that you have to look specifically into PFAS and ensure that you're, quote, innocent. PFAS is really no different than other hazardous substances when you're looking at innocent purchaser defenses under CERCLA. So when you're conducting your diligence at a brownfield site, you have to, as ASTM requires, look into any release or potential release of a hazardous substance in order to meet your innocent purchaser status. Keeping in mind that there's no silver bullet here. This is a defense that you use in court because someone else is saying you're responsible for historic contamination. It's a very hard defense to meet. A lot of times courts find that a consultant missed something that it should have found, or with the case of PFAS, maybe you should have tested to see if there was PFAS. Maybe you need to remediate because that's a continuing obligation. I mean, it's really tricky. Like I said, PFAS isn't different than, let's say, a chlorinated solvent on these issues, but it's the risk that, no one really wants to look for it because we know we're going to find it. And we're pretty sure that the courts, when this starts to get tested, will say, yeah, you should have tested or you should have remediated to keep the defense. So it is a little unsettling to say the least. Joel, do you have anything to add?
When you're into a bona fide potential purchaser type of defense, how does it impact it that kind of PFAS are in everything, and even like a septic system, it's kind of widely known that those are going to have a certain concentration of PFAS in the discharge. So how do you maintain that we're not doing any disposal of a hazardous substance defense?
Yeah, that's the question, what the reasonableness standard is, because to keep the defense, there can't be a continued release. So again, this is a court deciding what you should have done. I mean, we always use the example that if you do phase 2 sampling and it's possible that the contamination is going off site, to continue to meet the defense, you've got to probably test to see if it is going off site. You might have to remediate. And again, this is something you're arguing in court when someone is already saying that you're responsible for the contamination. So there's no like 100% you do this and then you get the defense. Unfortunately, it's a court deciding whether you did all you could to show that there was no continuing release.
And I think as far as eligibility for funding from EPA and things like that, we would hope that they would understand the reasonableness of the kind of septic discharge would be the answer there.
That's what we'd argue.
Well, Mark, that brings up the passive receiver concept, which is a huge deal right now. Passive receivers, those who are just getting the PFAS from another source or through a septic system. They're not the ones that are using the PFAS in their day-to-day operations and certainly not manufacturing it. So they are passively receiving it and yet still have potential or technical CERCLA liability. So Congress understands this, and there have been bills for the last 5 years trying to address the passive receiver problem. There isn't a solution legislatively yet. EPA has a enforcement discretion policy about passive receivers, but it's just a policy. So it's not going to be binding if you actually get sued.
It's also at some level, it goes back to, again, what we talked about at the beginning and the quality of the investigation. Like you can have a site that has tons and tons of PFAS in the groundwater underneath it, and the site never actually used or discharged PFAS because, again, PFAS is highly mobile. So if you can establish that through a well-developed conceptual site model and appropriate testing, you might be able to create the data-driven separation between those two media to show that the site is the source. But you have to have the investigatory sophistication to do that. And frankly, not that this is a plug, most consultants aren't very good at that. We are, though. We're really, really good at that. Is my bias shown through? Is that?
I think that kind of leads into the next question you have on the list about the role as an investigator. And, my kind of thought process on it is when I'm designing an investigation where PFAS is one of the issues, I'm way more concerned about what's upgrading to the site than I am with a traditional contaminant where we're gonna have a defined source, because you're gonna need to get even things like surface water runoff that comes onto the site are going to have a signature that you're going to want to be able to identify. And it becomes a much more robust investigation from that point of view and a much more complicated conceptual site model. There's definitely a lot more that goes into it when you have to consider that there is definitely an offsite upgradient component to it, instead of very unlikely that there's an offsite upgradient component, like with a chlorinated solvent or something like that.
That's a good point. And I think with the phase 1 versus phase 2 question, with the phase 1, you have to consider PFAS. We've talked about that at length in the discussion. But whether you do a phase 2 is really case specific. I mean, we're not recommending phase 2s for every single deal. It would depend. A lot of our clients may hold on to property for a very long time. Others, if they plan to sell property in the next few years, flip it quickly, that you're going to be more worried that the next buyer is going to ask for sampling. If there's a lender involved, the lender may be asking for sampling. So I think the decision on whether to do phase 2 sampling will depend on what the use of the property is, whether you have these external stakeholders that may require sampling, whether you're planning on-site development, which certainly with the brownfields, and you have to think about whether you're going to come across PFAS in the construction, whether there's off-site disposal, those kinds of costs, those all need to go in the decision as to whether to conduct phase 2 sampling, aside from the innocent purchaser defenses, which are really separate. So there's practical considerations, and I don't think there's ever the same answer. It's always dependent on what, who the client is and what the use of the property will be.
So I think for our last topic of discussion here, we can talk about what are the legal implications if PFAS is not tested for and later discovered.
It's a lawyer answer, but it's always it depends, right? It depends on what you should have known when thinking about a brownfield transaction at the diligence stage. What should a reasonable person what should that reasonable person have known at the time? And we're all, especially when a litigation occurs, you're all hindsight 2020 Monday morning quarterbacking a situation, saying that of course you should have done an investigation. Of course that phase one missed a PFAS signature that would have led to a recommendation for phase two sampling. But it's not always that simple. So it really does depend on the situation. If you don't do testing, acquire a property and later find out that there's PFAS on the property, then you have to go back and evaluate a couple of things, but primarily, at this point you have PFAS on your property. I would want to know, was it there when I purchased the property? Or to Dan's point, it so quickly migrates in the ground or deposits in the air, it might not actually have been there when you acquired the property to begin with. So it gets very difficult and nuanced when you're talking about not doing sampling on the front end and later sampling and finding PFAS in soil, groundwater, sediment, etc.
Joel, I'm going to have to throw the foul flag on this one because you started this with a "it depends" modifier, and I'm telling you, consultants have long patented that response. It's off the table. That's our language. It depends.
We can fight about that one, I think, because we both own that phrase.
Great. Well, I guess we're pretty much wrapped here. Were there any other topics or questions people wanted to go over? I think we're probably a little over time, but yeah, anything any of us want to add?
I got a couple of questions that,
Yeah.
If you guys just have a couple of minutes, I guess. Have you guys been seeing, and I guess what have you been seeing for PFAS remediation at sites? Anything really beyond bringing it to a landfill or protecting receptors, really? Or is there kind of, that's still the cutting edge?
I'll give you one example, Mark. We're doing a New Jersey site that was a PFAS manufacturing facility. So we're talking about parts per million, high parts per million in groundwater, not parts per billion or parts per trillion. So it's, legitimate site. It will never be cleaned up in our lifetimes or our grandkids' lifetimes. It's not going to be cleaned up. There's too much. It's too complex to get it out of the ground, bedrock and otherwise. It's just there. So it is going to be a matter of containment and addressing the primary risk receptor of drinking water. I mean, it's not really a dermal exposure issue. So we're designing a hydraulic control system that will contain as much PFAS on site as we possibly can to prevent migration. That PFAS groundwater is being extracted. We're developing a foam fractionation process to get as much of the PFAS out of the water as possible through foaming it up, disposing of that foam through incineration, and then treating the rest of the treated groundwater with carbon. It's the best that we've come up with at this point.
I guess, what about more toward the appetite for cleaning up PFAS versus shifting the risk through insurance mechanisms and things like that? Have you guys seen more of one or the other when it compared to a different type of contaminant or a more understood one, I guess?
The issue with the insurance is if there's known PFAS, you're not going to get covered. You might have coverage under historic policies, old policies. I think Joel mentioned that, and you can check those, but it's really a different type of site. I haven't seen a situation yet, knock on wood, where you purchase a policy that covers PFAS and then you bring a claim. I know that they'll be coming, but I haven't seen that.
Okay.
Joel, you can probably comment more on the remediation. From a deal perspective, what I see is we have had very few occasions where the PFAS is not detected in a phase two. Usually it is, but we have had some decent couple times where there's nothing, so that's great. And for the most part, it's just figuring out, are the levels too high? What are the planned uses for the property? I haven't seen a deal crater for PFAS yet, but it's early. I'm sure that could come.
Okay. And any impacts from the kind of states starting to release these background soil studies that are showing, background levels at like 3 parts per million and finding PFAS in 97% of the samples, and or we're waiting for regulation to catch up, I guess.
I'm very cognizant of that anthropogenic PFAS concept, Mark. It's everywhere. And so even if you are responsible at a site for PFAS, that doesn't mean that you're responsible for all the PFAS. I understand that it gets into a joint and several liability and mixing of plumes and whatnot, but if you can distinguish your PFAS from anthropogenic PFAS through fingerprinting or other emerging technologies, or using the, like you say, the soil background or air deposition or any other way to show that it's not like TCE. If it's there, it's because there was a use and release of TCE at that site or nearby. So I would certainly use that as an arrow in my quiver to try to avoid being fully responsible.
Right. I guess brings it back to being very cognizant of how you conduct your investigation and really diving into the forensics and understanding what comes from where and how it transports and how it transposes and all those things.
Well, I think that'll do it for us today. Heather, Joel, thank you guys so much for joining us.
We enjoyed the opportunity, and thanks again.
Yeah, good to talk to you guys. Thank you.
Absolutely. For folks out there who might want to get in touch with you or Thompson Hine, what's the best way to go about that? And do you guys have any things you want to plug, like possibly that the newsletter that first got HRP interested in the topic?
Sure. You can find both me and Joel on Thompson Hine's website, thompsonhine.com, and our contact information, emails, and phone numbers are there, and we'd love to connect with you.
Yeah, and we're all staying abreast of the quickly moving regulatory and litigation developments in PFAS. We've got an upcoming Thompson Hine webinar that you can use the Google machine and find us recording of that soon. And we'll continue to issue alerts like the one that caught your attention last month.
Fantastic. And we'll make sure to include links to all of this in our show notes. All right, everybody. Thanks for joining.